Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out on the channel regularly, one, thank you very much. Number two, you will know that we have been sounding the Rahimi alarm bells ever since the day that opinion dropped. And we said there was all sorts of problematic language in there that could have very long-lasting and far-reaching implications. Today, we're going to show you a case that got Rahimi'd, but it got Rahimi'd for a different reason because, well, it was actually relying on the Fifth Circuit's initial ruling in Rahimi, which of course the United States Supreme Court overturned. But it could have real big impacts for a lot of people nationwide. So let's all slow it down, let's geek out, and let's talk about a huge case that no one is talking about. Okay, before we get going too far down the road we're going down, let's remember that this video is being brought to us by the Sonoran Desert Institute. That's right, get ready to arm yourself with education today. Get ready to launch your career in the firearms industry today through education. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through education. Listen, the Sonoran Desert Institute has a program, a certificate, or a degree for just about anything that you may be looking for. So for more information, visit them down there in the description box below. Or easier yet, just visit them at sdi.edu. Okay, America, here's what we're talking about. We're talking about the case of United States versus Perez-Gallan. It comes out of the Fifth Circuit. Why is that important? Well, because Rahimi came out of the Fifth Circuit, and I think if we're going to start breaking down which circuit is perhaps the most pro-Second Amendment circuit out there, the Fifth Circuit certainly is going to be ranked right there near the top, if not number one. Now, this is a challenge to 18 United States Code Section 922 G8C2. What is that? Well, that's the federal statute that prohibits you from possessing firearms if you're under some kind of a domestic violence restraining order. But here's the important distinction, because when we take a look at how Rahimi had gotten disarmed, Rahimi had been disarmed under 18 United States Code Section 922 G8C1. So technically, this is a different portion or subsection of that statute. And that's exactly what the defendants were arguing here. They're saying, hey, listen, the United States Supreme Court has found that the section that actually applied to Rahimi, that was constitutional. But the rest of the finding from the Fifth Circuit, that is that 922 G8 in its entirety was unconstitutional. Well, that still remains the law of the case. And they started arguing things such as the rule of orderliness and other things like that. And it's essentially, you know how I get sometimes critical when government's arguing standing and things like that because they really just don't want to actually get to the merits of the argument? Yeah, that's exactly what the defense does in this situation. But the bigger problem for the defendant in this case, other than the fact that Rahimi was totally working against them now, was that this is a facial challenge to that statute, which means that they would have to establish that under no circumstance imaginable to man could we ever apply this law in a constitutional way to any person anywhere. That is an incredibly lofty burden. And while it's almost impossible to do, it becomes even more impossible to do when Rahimi has already said that other portions of the statute which disarm what? Dangerous people, those have a constitutional basis. So the defendants knew that they were really up against it here, and that's why they made all sorts of arguments like, no, apples to oranges, this is still good law, we shouldn't even be hearing this, the original ruling stands, okay? But ultimately the Fifth Circuit pointed out that no, we can revisit these cases, especially when one situation in which this may naturally occur is when an intervening Supreme Court decision fundamentally changes the focus of the relevant analysis. So with that in mind, the Fifth Circuit points out that, hey, listen, the question then is whether Rahimi 2024, despite expressly ruling only on C1's facial validity, is nevertheless a sufficiently unequivocal overruling of Rahimi 2023, such that Rahimi 2023's holding as to C2's facial invalidity no longer binds us. Okay, and understand now, Rahimi 2023 is the one that came out of the Fifth Circuit. Rahimi 2024 would be the Supreme Court's ruling. Now, the Fifth Circuit then went on to point out, in light of the two errors the Supreme Court identified in the panel's decision, we hold the entirety of Rahimi 2023's G8 analysis has been unequivocally overruled. Okay, and while a lot of people can debate what does Rahimi really mean or maybe not mean, how dangerous is Rahimi or isn't it, there is a very clear rule of law that has come out of the case, and it is this. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Now listen, I want you to understand that the Fifth Circuit didn't stop here. They didn't take any shortcuts and say, well, Rahimi, the 2024 ruling out of the United States Supreme Court, clearly proves that the challenge section here of the statute is constitutional. No, they said it warrants another look. And they do go back and they do another look and they look at the how and the why, but they're also doing it through the lens of the Supreme Court's analysis in Rahimi. And as you recall, there were certain laws that the majority in Rahimi found, such as the surety and going arms law, that justified the disarmament of dangerous individuals. And so the Fifth Circuit wrote, we know from Rahimi that C1 is facially constitutional because, taken together, the historical surety and going arm laws invoked by the government confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. And again, with that in mind, and considering that this is a facial challenge to the statute, the Fifth Circuit points out, why applications of C2 might present closer calls than do applications of C1, Perez-Gallan's facial challenge still fails because the provision is not inconsistent with the Second Amendment in all its applications. Okay, does that mean if you're subject to a domestic violence type protection order, you will absolutely positively be disarmed? No, the court left a little bit of wiggle room as it relates to some of these mutual orders. You know, sometimes courts don't know which side to believe, so I'm just going to throw orders at both sides and tell you all to leave each other alone. The Fifth Circuit was careful to point out, finally, we acknowledge some potential applications of Section 922 G8C2 appear problematic, and we do not hold that the statute is or even likely to be constitutional in all its applications. As one judge noted in Rahimi 2023, so-called mutual protective orders pose a real concern. Okay, so will we take a look at the reversal of fortunes that Rahimi 2024 did to Rahimi 2023, and then the Fifth Circuit goes back and does a reanalysis and uses the Supreme Court's test as announced in their Rahimi decision. The Fifth Circuit now comes to the following conclusion as it relates to disarmament of individuals who are subject to domestic violence protection orders. Because 18 United States Code Section 922 G8C2 is not unconstitutional in all its applications, Perez-Gallan's facial challenge fails. The judgment dismissing the indictment is reversed and remanded for the district court to consider Perez-Gallan's as applied challenge in the first instance. And so that's not the end of the story, and Perez-Gallan still has a chance to thread the needle, and it's actually an easier needle to thread in some ways because he only has to argue that it is unconstitutional as applied to him. But the facts of this case show that Perez-Gallan was in fact subject to a domestic violence protection order that did order him to be disarmed. And for that reason, I don't like his challenges one way or the other. And I candidly don't like the likelihood of success currently under the current case law for anyone to challenge the constitutionality of a disarmament order against an individual who's been accused and found by probable cause to have potentially committed a domestic violence offense. And certainly post-conviction for that, I absolutely positively do not like the chances of that changing anytime soon moving forward. Okay, the case once again is United States versus Perez-Gallan. We're going to link up the order of the Fifth Circuit down below so that you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.